The Point of View is brought to you by Cowbell Coffee. Cowbell Coffee. Taste it, love it. Kel Charcoal Toothpaste. Kel Charcoal. Happy smile. Enterprise Life. Enterprise. Your advantage. Bell Aqua Active. Bell Aqua Active. Stay true to originality.
Welcome to The Point of View. This is your favorite current affairs show on television. The Point of View gets the right guests, asks them relevant questions on issues that matter to you. Tonight, our show is captioned Parliament in the Eye of the Legal Storm. The past week, they've been involved in very interesting standoffs. The first one has to do with their police's attempt to arrest the Member of Parliament from Medina and Parliament's refusal to allow this to happen. We'll discuss that. We'll also talk about Parliament's tango with the General Legal Council. Attorney General issued a letter rebuffing Parliament for trying to overextend its powers. So tonight, we're going to try and understand whether Parliament is overextending itself or whether they are actually pushing the frontiers of legal jurisprudence. We'll be right back with a very exciting panel. Stay with us.
It pays to stay original. Choose Bell Aqua Active and stay true to originality. Try it. This investment has been vested and approved by the FDA.
Enterprise alive and see we are moving. We are cruising. This is how it feels like to have Enterprise Life in your corner. They give solutions that make life easy every day. So now I can focus on my dreams.
Enterprise Life wa when she share more. I don't know. Yeah, no who do you move?
Hey.
I shock you.
We've got life. Dream big. Go on, dream big with us.
Dream big with us. Enterprise, your advantage.
Welcome back. So tonight we have two parts to the same issue, Parliament in the Eye of the Legal Storm. In part one, we examine the case of Francis Xavier Sosu. He organized a demonstration at Medina, his constituency. The police were there. After the demonstration, they tried to arrest him. He wouldn't agree. He says he was on his way to Parliament, or he was doing his parliamentary duties, and therefore he ought not be arrested at that stage. The Speaker of Parliament was then written to by the police requesting for Francis Xavier to be released. The Speaker declined. Now, is Parliament overextending itself, or is it a case of a misunderstanding of the law? I have three guests. In studio, I have the MP for South Dai, Roxin Eche Dafiamepo. He and the MP in question have actually initiated a private member's bill for the second issue we are discussing tonight, which is Parliament trying to intervene in the case of the 499. Honorable, welcome to the show.
Thank you, Bernard.
Great to have you. We also have private legal practitioner, Mr. Sami Daku. He used to be a journalist, but these days he's a legal practitioner. Sami, great to have you.
Thank you, Bernard.
I will also be joined on the Zoom session briefly by the Dean of the Faculty of Law, UPSA, Professor Kofi Abuchi. Prof, good evening. Thanks for joining us. Okay, Prof, we can see your mouth moving, but I think you are muted. So if you can say good evening again.
Yes. Can you hear me now?
Yes, please. I'm going to start with a quick...
Good evening.
Good evening. Thanks for joining us. I'm going to start with a quick excerpt of my interview with Mr. Kwesi Fori earlier on radio today to try and clarify circumstances under which the police stormed the church premises at which Francis Xavier was supposedly preaching. Here are a few excerpts of that interview. What is the official position on Francis Xavier Sosu, MP for Medina? Is he under arrest? Is he wanted? What is the issue?
Yes. Following the Honorable Member of Parliament writing to the police to seek protection for a demonstration, police heeded to that and provided him the needed security. During the demonstration, violence became part of it, where they were burning lorry tires, blocked the entire road in and around Medina, preventing free vehicular flow, among others, and causing a lot of nuisance in and around the community. The policemen on the spot decided to question him on the issue by inviting him to the police station. He quickly entered the car, and a man in a police uniform drove him off from the place. By so doing, he nearly knocked down 2 police officers and some members of the public. Those 2 senior police officers lodged a complaint against the very officer who drove the vehicle away. Apart from that, severally, the police have invited the Honorable Member of Parliament to come in and answer or assist an investigation regarding the flouting of the public order law, which enjoins that a leader or group of leaders responsible for it, should anything go bad, should be held responsible. And he failed to report. Again, the CID headquarters wrote a letter to the Honorable Speaker of Parliament informing him of the development. And as you rightly said, the Honorable Member of Parliament did not turn up. And all that we are saying is the police is at 1, not responding to a legitimate call or request, because we know that the Constitution empowers the police, to conduct investigations and other matters bordering on security. And as a member of Parliament, as a leader in his community, we expect that he will also show that respect, that gesture, good gesture, towards the police.
So let me get this straight. You are saying there are two issues.
So he has not.
No problem.
And the police have designed tactical moves to get him arrested.
Fair enough. I just wanted to clarify.
And by failing to do that as a citizen of this country, it's an attempt trying to lure the police into an arena of dispute. And that is not fair.
So that was Kwesi Fori. It's a longer interview. You can get the full interview on SoundCloud. Now, let me start with Professor Abuchi. I noticed you tweeted yesterday, October 31, quote, "The police are not duty-bound to inform or seek the permission of the Speaker before effecting an arrest of an MP. The authority of the police to arrest extends to everyone except the President. An MP can only evade an arrest if he is on his way to or from Parliament," unquote. Prof, can you elaborate on this point that you tweeted yesterday?
Well, my tweet was just a humble contribution to the conversation. The issue surrounding the capacity of the police to arrest members of parliament is one that has generated a lot of controversy and confusion over the years. And my tweet was just designed to see if I can bring a little clarity from my own perspective on this. The capacity of the police to arrest people essentially has no limit at all. The Constitution has been clear that that limitation was restricted to the president. Below the president, all of us are subject to arrest by the police. Now, the MPs enjoy a special period of immunity, and that period of immunity only extends to their being on their way to Parliament or on their way from Parliament. In other words, the drafters of the Constitution have designed the arrestment process of MPs in such a manner that their parliamentary function will not be obstructed by way of the process of arrest. And when they leave Parliament, Parliament shall not be used as a trapping point to get them arrested. And so, for example, you can't have the police lay in ambush in front of Parliament House or outside Parliament to arrest them. And the purpose is to ensure that their parliamentary work is not obstructed or interfered with unduly. Otherwise, MPs, like all other people, are subject to the arrest, the arrest and the prosecuting powers of state. And as the discussion wore on, I got the sense that there's some confusion as to whether or not the Speaker of Parliament must grant his permission. And I think that confusion arose from the standing orders of Parliament, which is an internal, as the Constitution has, or rather as the Supreme Court has defined it over the years, it's an internal working instrument within Parliament. It doesn't trump the Constitution. And so as a matter of operational courtesy, the police can't comply with that. And I think over the years they've been complying with that. But in terms of the strict construction of the law, members of Parliament are not or cannot be shielded per se by the Speaker of Parliament.
Let me take Honorable Roxon's response to that, because I know you completely disagree with this.
Yes. Thank you, Bernard, and good evening, Prof. I disagreed with Prof on two grounds. There's nothing in our standing orders that is alien to the Constitution. In fact, the provisions on the immunities and the contempt provisions as captured in our standing orders were directly lifted from the Constitution without more. In fact, the principle is that if you do that and they contravene the Constitution, it's null and void ab initio. Mm-hmm. So Parliament, from the get-go of the Fourth Republic, simply lifted the constitutional provisions and inserted them in the standing provisions, our standing orders, as the provisions governing these matters. Mm-hmm. The other disagreement I have with Prof is that he's giving a blanket submission that in terms of arrest, a member of Parliament can be arrested when he leaves Parliament. No, that's what it says, that we are all subject to arrest. But the Constitution is very clear. You can arrest, I will agree with him that you can arrest a member of Parliament when he's discovered committing the offense in flagrante delicto. That is when he's in the act. Then that one, the immunities covering you will evaporate. You will have to be apprehended because you are in the act committing the offense. But where the police are bundling about allegations, you saw their statement. All the things they have said about Sosu's involvement is that he's alleged to have done that. The proper procedure pursuant to the constitutional and our standing orders is to go to the Speaker. In any case, there are three processes to arraigning somebody who is a suspect in respect of a crime. The commonest approach the police have adopted is the arrest approach. Now, there's even a citizen's arrest. When you're about to commit a crime, you are committing a crime, or you've committed a crime and you are absconding from the crime scene, you can be arrested by citizens and handed over to police. Mm-hmm. The other one, I think, that is applicable in this matter, if they think that Sosu is evading arrest, is to issue a criminal summons. Through a court? Yes. You prefer the charges. You file the summons. you have him served through the procedures laid down in the Constitution. It would have quietened everybody.
So if I get you, you are not against the fact of arrest. You are against the procedure adopted to effect same.
Exactly, because you see, what the police keep talking about is that they want to interrogate him. Interrogation can take many forms. What do they want? They want to take a statement from him. So the first approach in accordance with the criminal procedure will be the caution statement, and then the charge statement if they make a prima facie determination to arraign. So all that can be served by the issuance of a criminal summons. Criminal summons is a court process. You issue it, you lay the charges, you add the facts to the charge, you file it in court, you serve the accused person. In that case, he moves from being a suspect to an accused. So he will be in Parliament. The process will be served through the office of the Speaker. It will be served on him.
Okay.
Then now he will go to court and defend himself in the matter.
Okay, you've made 3 clear points. Let me take Sammy's comment and I'll come back to Prof if he has any rebuttal. So you have said, number 1, standing orders don't contravene the Constitution.
At all.
Number 2, if the person is caught in the act, he can be arrested. But number 3, your issue is about the procedure. They could have issued the criminal summons.
Yes.
Sammy, where do you stand in this issue?
Well, I think that I agree with those who say it's not about whether police can arrest, but it's about how police arrest a member of Parliament.
Okay.
And the reason why it's about the how is that in the Constitution, in Article 117, 118, a particular procedure is provided for when you want to either serve a sermon or arrest a member of Parliament. Now, this is how it goes. It says that you can arrest a member of Parliament. You cannot arrest a member of Parliament when he's on his way, attending at, or returning to. And all this has to do with parliamentary business.
Yes.
So it means that if he's not engaged in a parliamentary business, you can arrest that person without going through anyone. Because it does not say go through anyone. If you read Article 117, well, it says that sermons shall not be served on the Speaker and Member of Parliament. It does not say you have to go through the Speaker.
Okay.
And it also says that you cannot arrest when the person is involved in a parliamentary business. So my point I'm making is that police can arrest an MP if it has nothing to do, at the time of the arrest, he was not engaged in a parliamentary business. I think that the police have the right to arrest such a person. And when he talks about arrest, we have what we call arrest with warrant and arrest without warrant. So you can arrest without a warrant when, like he said, the person is caught in the act, like he said, in flagrante delicto, when the offense is being committed in your presence. So that if the police at the time they allege the MP for Medina had committed an offense and they were there and they saw it, then they can arrest him without a warrant. But that is where the issue becomes a bit funny, because if they attempted to arrest him and he said, I'm on my way to Parliament, then my argument is that he may be covered by the Constitution, which says that when they are on their way, then you are not supposed to do the arrest.
Which is exactly, I think, what he said to the media.
But it does not mean that he cannot be arrested. It means that you have to arrest him at another opportunity, which means that even on a Sunday, and if the police attempted to arrest him on a Sunday, that is outside the arrest without a warrant. So I was expecting that if you want to arrest somebody on a Sunday because the time you wanted to arrest him, he had escaped, then you need to have procured a warrant. You go to the building in which he or she is in it. Whoever is in charge of the building, you tell the person, I have an arrest warrant for this person. The law says that the person is obligated to allow you free access. Then you can cause the arrest. And the way we talk as if MPs cannot be arrested is interesting. Look at this typical case, and it's about Kennedy Ohene Japan. In April 2012, he was arrested on the charge of treason. And the time he was arrested, Parliament was not in session. Parliament was on recess. You don't sit in April, isn't it? And so
we sit in April.
You sit in April. But my recollection is that...
Yes,
you don't sit
Easter
in April.
break.
Yes, that's the Easter break. He was arrested at the time that Parliament was not in session. So there can be no excuse that I'm attending to parliamentary business, unless maybe there are committee meetings that have been scheduled. And that is why I also will agree with those who say that maybe we must go for an interpretation as to parliamentary business, because some people have said that if I'm with my constituents and we are discussing parliamentary stuff, it should be considered as parliamentary business. So maybe we may want to limit the definition of what constitutes parliamentary business, because what I do know now is either you're on the floor of parliament or you are engaged in a committee.
All right. So far,
session.
both of you have agreed on the issue of the how. Let me just take Prof's closing comment on this one, because I know he'll leave. Prof, so just to be clear, my two in-house panelists are saying the issue of fact of arrest is not in doubt, but they are both talking about procedure, although they vary slightly. What are your thoughts on that as we wrap up this angle of that conversation?
Well, that's the point that I made earlier. First of all, 117 is the relevant provision. 118 doesn't even come in at all, because 118 speaks about service as a juror or witness in court and stuff like that. But 117 specifically deals with the issue of whether or not an MP can be arrested, or immunity, so to speak. And so 117 is titled immunity. The focus, therefore, is on immunity, and it's a restricted immunity. The reason why it's a restricted immunity is because the focus is on protecting the member of parliament on his entry into parliament, on his way from wherever into parliament, and then on his exit from parliament when he's leaving parliament to wherever he has to go to. The law protects the MP in that period. So it's a transitional immunity that is granted to the MP. In the question of the arrest, and I think Mr. Samir Aku's position is pretty much in tandem with what I'm saying, so I don't think I have much objection with that. But the issue of the arrestment of a person using the warrant, some of these things create confusion in the minds of people. And I just want us to be a bit clear, because there's a danger sometimes that everything we're saying today has ramifications for the future. A police officer can arrest people, or anybody for that matter, without a warrant. The reason the police do not need a warrant is because the criminal procedure laws of Ghana gives the police the right to arrest people on mere suspicion. A private citizen can arrest a person on mere suspicion, but there's a danger to that. And the danger is if the offense is not actually committed, the private citizen's arrest becomes unlawful. And that unlawfulness can give rise to an action for unlawful arrest by the person who's arrested. But when the police officer arrests you on mere suspicion, but it turns out that you have actually committed nothing, you can't sue the police officer for unlawful arrest. And the reason is because the law protects police officers because of the nature of their work. The nature of their work results in all kinds of arrests in the period. So I understand the difficulties. And let's be honest, let's be clear. I think that going through the speaker as you arrest a member of parliament, it's not only a question of courtesy, but it may also be useful. What is useful is distinguishable from what is legal. It is useful because it is only a Speaker of Parliament who can determine, for example, whether there's parliamentary business ongoing, officially speaking. And it is the Speaker of Parliament who must account for all members of Parliament, so to speak, in terms of these being members for official reasons. And so it makes sense to go through a Speaker of Parliament, given that a particular seat may be rendered legally vacant by reason of the operation of law, i.e. through an arrest process. So it makes sense to go through the Speaker of Parliament. But that is one thing from saying that it is legally mandated. And on the question of the standing orders of Parliament being the same as the Constitution, I think that Honourable Dafamekbo may want to look at the Constitution Article 117 and the standing orders of Parliament. And you can see that in the minimum, it may be an expansion of 117. However, 117 doesn't indicate that Parliament can make further rules in the expansion of that. 117 is specific on the question of an immunity, a restricted immunity, which is given to members of Parliament for the period of their entry into Parliament and for the period of their exit from Parliament. And beyond that, members of Parliament, like all other citizens, are equal.
All right, just a quick point there. 122 also talks about contempt, the act where somebody obstructs a member of Parliament in the discharge of his duties. So whilst you use 117 to talk about entry and exit, there's also a point about obstructing a member of Parliament in the discharge, where then it becomes expanded. So if the member of Parliament says that meeting with my constituents is part of my duties, which Sami said, and by trying to take me from that space, you are obstructing me in discharging my duties, you, the officer, could also be in contempt. I'm sure that can be argued. So I'm just saying that maybe we shouldn't construe this to just be a question of entry and exit, because you also have to add 122, which talks about what is contemptuous of Parliament, right?
Is it directed at me?
I wanted your comment on that, but if
okay. Yes, the question of contempt of parliament is another animal altogether. That's a huge one, and the reason is because I think that's one particular aspect of parliamentary practice that again we need an intervention of the courts. The question of what constitutes contempt of parliament, whether contempt of individual members of parliament constitutes contempt of the corporate entity parliament, and the kinds of things that constitute contempt. In this particular case, some may argue that the obstruction here is referable to illegal or unlawful obstruction. So that if an MP is going to Parliament to do his work, and I block the MP from going to do his work by any means for the matter, and it's determined that my blocking the MP from going to do his work is unlawful, of course that would be obstruction. The question as to whether a lawful obstruction of an MP, and under the Constitution, the only lawful detention or the only lawful restriction on a person's movement under the provisions of Article 21, which is the right of movement, among others, the only lawful restriction on that is the process of arrest. And so the question of whether an arrest, when legitimately, properly exercised, can constitute obstruction, again,
it's a different issue. All right. The court Fair enough. We'll take a short break. Thank you. We're talking Parliament in the Eye of the Legal Storm. Part 1 is about Parliament versus police. We'll take closing comments on that, and then we'll jump into Part 2, where Parliament has tried to help the 499 law students, but the Attorney General doesn't seem to think they have the locus. We'll be right back. Stay with us.
Mama Josie. Fe.
Different era, better result. Time has changed and time has brought Kel Charcoal Toothpaste, healthy gums, anti-cavity, fresher breath, and it whitens teeth. Kel Chocolate Toothpaste, Sankofa.
Yenchi, Kel Chocolate Toothpaste.
Happy smile.
Creamy Plus is a fully skimmed evaporated milk. Creamy Plus is available in a shop near you.
This message has been vetted and approved by the FDA.
Welcome to Malaria 360. COVID-19 seems to be getting all the attention lately. But right here, our focus is on everything malaria. I know we've all become a little paranoid lately. At the onset of the slightest fever, we begin to imagine things and start popping pills. But this is wrong. A simple test at a health facility is all you need to confirm whether or not you have malaria. This is why we say test and treat only when malaria is confirmed. In Ghana, when malaria parasites are found in your blood, you'll be given the appropriate anti-malaria medicines to treat malaria. Do not self-medicate. Adhere to all the COVID-19 safety protocols in place. Zero malaria starts with me and you.
Welcome back to The Point of View. Tonight we are discussing the police in the eye of the storm. It's police versus parliament. Actually, so parliament, not police. Parliament versus police. We're discussing this with Sami Dakum, a private legal practitioner, Roxanne Echedafiamepo, MP for South Dai, and Professor Ernest Kofi Abochi, Dean of Faculty of Law, UPSA. So let me end this segment with you, Roxanne. So what are MPs saying? That he shouldn't be arrested at all? No. They should come and arrest him in parliament?
No, not at all. Not at all. MPs can never say they should not be arrested. I've already clarified that matter.
You should issue a summons.
Yes, if the police are really minded in prosecuting the matter, they should issue a summons. But if they want to proceed on their first preferred procedure of conducting inquiry into matters, come through the speaker. That's all. But let me tackle Prof. I think Prof got it wrong when he says that Article 118 doesn't come in. You see, the issues under 117 is that the police are challenging the fact that Sosu says, I'm proceeding to Parliament as the Deputy Ranking Member on Constitutional, Legal and Parliamentary Affairs to attend an urgent meeting. So when that happens, then Article 118 kicks in. Then you need a confirmation from the Speaker to say that indeed this person is involved in parliamentary duties. So 118 says, the certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament.
I don't know, but read the heading of
immunity from witness summons.
Yes.
Witness summons.
Yes.
So it's different.
No, it is not. You see, it's a chain of provisions on immunity. So every provision is very, very important. When you are challenged that we intend to arrest you and you raise the issue of parliamentary duties, or you are in the middle of performing parliamentary duties, or you are on your way to Parliament, how is that verified? It is 18.2 that will give the verification. And it has to take the Speaker to say that, yes, at this particular time and day, that they accosted you for purposes of being for your freedom to be curtailed.
I'm sure we can split us about this because it's quite clear you're talking about witness summons, but
no,
you're saying that it's a chain.
I'm saying that
no
if
problem.
you look at from privileges, all right, all the way to...
But there were three immunities: from service of process of arrest, clear, from witness summons, and then from service as a juror.
And I'm saying that if you read the whole provisions,
you think it's related?
The only way the police can obtain conclusive evidence of your claim that you are attending Parliament has to come from the Speaker.
Fair enough.
Yes.
So give me, what's the end game here?
So the end game is that if you go to Order 30J of our standing orders, it is to the effect that the duties of a parliamentarian are not only occurring in the floor of Parliament. A member of Parliament can also engage in duties out of Parliament. So, for instance, the provision is that one of the incidents that can constitute contempt of Parliament is the fact that when you molest a member or officers in connection with their performance of duties in and or out of Parliament. So when Sosu says that, you see, but now when you are elected the elected representative of the people of Medina, you are elected to be a leader. So when the people of Medina are calling that come and lead us so that we exhibit our displeasure in respect of the horrendous nature of our roles in Medina, if you don't show up, they will replace you as a leader. So when you show up and you are leading them in their demonstration, for me, in my opinion, you are performing your duties for which they elected you.
But you must do it in a lawful way. So
he did it in a lawful way. Now the police said they will want to arrest you for something that now is an allegation. If you read their statement, why they are pursuing Sosu is that two persons have made an allegation. Read their own statement. It says it is alleged, it is alleged, it is alleged. If you are looking for an MP for an alleged commission of an offense, do you have to go to a church to go and hound him? And they are not even bold enough, sincere enough to admit to the fact
that... You've also invited the three policemen to come to Parliament. So are you going to say...
Sosu move the house.
Is Parliament saying that until those two people attend upon the privileges committee, Parliament will not hand over
Sosu
to them?
Parliament has not even spoken since this matter. Parliament only... Sosu moved the house.
No, but the Speaker said he will not allow Sosu to go.
No, Speaker didn't say that. Speaker said they should follow procedure.
I see.
He said they should do the proper. They know what to do. This is not the first time police are coming, or the state security or investigative bodies.
So how has it happened in the past?
In the past,
under Speaker Okwe, how did it
happen?
Under
Speaker Okwe, he invites them to his parlor. They invite the honorable member. If you have a lawyer, you bring your lawyer. The state agencies will come. Whatever interrogations will take place. If it's your statement, you write. Okay. If the office of the special prosecutor came, and that was how it was done.
All right. Let me wrap up on. Let's go to the next issue. I want to. So, 499 laws to. You wanted to make a comment?
Yes, I wanted to make a point. I respectfully disagree with his interpretation of Article 118. I think it's separate and distinct. It has to do with being summoned as a witness to attend to court, and has nothing to do with this one. The issue about
you read the Constitution as a whole.
I get it, honorable. The issue about the issue about going through the speaker.
There's no other provision. There's no other provision on authenticating whether or not a member is.
I agree, but you see, if somebody is being considered a witness,
yes,
it's not the same as if I saw him slap you.
What do they need? What did they need to sue for?
Simple English.
Yes.
If I saw him slap you.
Yes.
And they want me to be a witness, I'm going to help the court.
That is not.
It's not the same as.
No.
It's not the same as me committing an offense.
For all you know, they want to sue. Hold on. For all you know, they want to sue to give a statement, and they can use him as a witness against some other suspects.
What's your comment?
You understand me? Yes.
I understand where he's going, but I think we have to deal with the law as it is than as it ought to be. My point is that the issue about going through the speaker has only become what I call like a custom. That's what he was also referring to. That, for instance, the former special prosecutor, when he wanted to arrest Mahama Ayariga, wrote to the Speaker of Parliament for the Speaker to give permission for him to interrogate Mahama Ayariga. I think that is merely a custom and not something that MP should hold on to as if it's been granted by the Constitution. The point we are making is that an MP can be arrested if that MP is not involved in parliamentary business. Aside that, on the issue of Sosu's matter, I don't even understand what's going on. I think that we are splitting hairs over a very simple matter, because if you look at this, if you read the police statement, they are merely seeking to bring Sosu under what we call Section 3 of Act 491, which is the Public Order Act. And it has to do with responsibility of organizers or other persons of a demonstration, so that if you cause damage or if there is any damage to public property, you will be made to pay it. Or if you obstruct traffic or cause nuisance, like they say, burning, then the punishment is that you pay formerly 2 million, which will be now 20,000, or a term of imprisonment not exceeding 1 year. I don't think these are huge matters that should
to lead to where we are.
Yes.
And both sides have taken entrenched positions.
Entrenched position. And in a hybrid system, I think that everybody wants to show a bit of muscle.
Legislature versus executive.
But I think that what should happen is that the MP is a lawyer. He's led so many people to the police station. And he knows what to do. I always say he knows what to do. In Ghana, I've always said that our mode of investigation is so old that we must go into what we call intelligence investigation. Because all that I've heard from the police is that they want to take a statement from him. If you want to take a statement from someone, he's not obligated to write anything. So he can even come to the police station and say, I won't say anything. Or he can simply come and say, I deny the allegations against me, I'm innocent. Then what are you left with? But I foresee why all this is happening. All this is happening because there's been a trend recently where when people are invited to the police station, even if they come willingly, they are arrested, detained, and denied bail until 48 hours, and they are quickly arraigned before the court. And I'm foreseeing that maybe the Honourable Member of Parliament does not want to become that example so that the police can say, okay, we've dealt with a pastor, we've dealt with a celebrity, and now we have added an MP. And so that may be why he's resisting. Because other than that, he's like I said, he's a lawyer. He knows what to do. He can go there with a lawyer and then ask for, he's entitled to what we call self-recognizance bail. But I'm sure the fear is that, will I be denied bail? And if I'm denied bail, that's going to hamper my work as a member of Parliament, because Parliament is now in session.
Interesting. Let's deal with the Attorney General. So Parliament made a very strong case for the admission of the 499. We know this matter. They directed the General Legal Counsel to admit the 499. A couple of days later, Attorney General writes a nice love letter back to Parliament, to the Speaker, and says, respectfully, he says the General Legal Counsel cannot be directed to proceed and admit anybody because in accordance with Section 13(1)(e) and F of the Legal Professions Act, the power to regulate admission of students to pursue courses of instruction, etc., etc., is vested in the GLC. And the GLC, in performance of their functions, comply with any general directions given by the minister. Therefore, he says in his opinion, the provision underscores the capacity of the executive, of which he is a member, not the legislature, through the minister responsible for the General Legal Counsel. And then he goes on to say, while all this is going on, he is working based on the direction of the president to make the necessary interventions on behalf of the 499. But he also corrects a few erroneous impressions that were stated in the story. I'll take Prof's comment on this before I come to the studio. Prof, again, Parliament, they have issued a directive to GLC, and the GLC hasn't even responded, but the Attorney General says you don't have the power to do this. What's your mind? Where is your mind on this matter?
Can you hear me?
Yes, loud and clear.
Okay, so yes, my video is up, unfortunately. I'm not sure what happened, but I just...
We can hear you clearly, so go ahead.
Okay, forgive me, but I probably would just want to spend just about 30 seconds to make a comment about some of the things that were said about the arrest. And I do totally share Mr. Samidako's concern about the fact that we're not even talking about the merit of the arrest. Unfortunately, a lot of the conversation has muddled both the merit and the process. We're not talking about the merit at all. As to the legality of the demonstration, as to whether or not the police have a legitimate case in pursuing him, all that nobody has spoken about. What we're talking about is the process and whether indeed he could be arrested, and not just him, but whether every and each member of Parliament could be arrested and subjected to the process of the law. So unfortunately, the issue is so politically heated that when things are politically heated, as I've said before, a lot of the conversation becomes irrational. And people are just not willing to listen to anything. I mean, they're just entrenched positions. And because of that, it's so hard to clarify issue and to bring clarity to the conversation. I think I still maintain the fact that every member of Parliament can be arrested with or without the Speaker's consent. It is operationally, however, wise and functional. And for purposes of institutional harmony, it makes a lot of sense for the police to usually cooperate with the office of the Speaker, so that the Speaker, who must account for his members, is aware of where each and every member is at any given point in time as far as the judicial processes of Ghana are concerned. And that makes a lot of sense.
Let's deal with the Parliament telling General Legal Counsel to admit people. Attorney General says that's not your job.
Again, this reflects the issue of processes as to whether or not the substance itself may be good, but the process may be wrong. The Parliament as an institution is tasked with the mandate of lawmaking. Beyond the mandate of lawmaking, Parliament is tasked with the mandate of oversight. And beyond the mandate of oversight, Parliament is tasked with the mandate of representation. Now, Parliament appears to be exercising the second mandate, and the second mandate of oversight, providing oversight over bodies. But the way Parliament has gone about it is a bit problematic, in my opinion. And the reason it's problematic is because Parliament's oversight function is also clearly defined. And very often, Parliament exercises that by public hearings or committee hearings in respect of specific agencies and sectors. And Parliament has the additional power through a variety of mechanisms, such as urgent questions that are filed before Parliament and invitation of specific ministers to answer questions. Parliament can invite ministers, sector ministers, or persons who have charge over agencies to appear before Parliament and to answer questions in respect of relevant issues and matters. Parliament could have exercised that. The GLC is not fully autonomous. It still falls under an agency organ of state. Ultimately, the Attorney General has a seat at the GLC. And so the Attorney General could have been invited. Indeed, the Attorney General has exercised the prerogative and the proactive authority of responding to the letter, which tells you that the Attorney General sees this as directed at him. He has a representation at the GLC. And so the Attorney General could have been treated as the one with some oversight responsibility over the GLC and probably brought to Parliament and questioned. And ultimately, there are some some punitive consequences, even if they are not hard punitive consequences, but there are some kind of punitive consequences, including passing a vote of censure in ministers. So ultimately, Parliament is not without authority. Ultimately, Parliament is not without the capacity to bring some influence to bear in respect of what is happening. But the process chosen is simply unknown to me. As a lawyer, I haven't come across this process where Parliament would issue a direct order to an agency of state, to a statutory body, and directs the statutory body to do something. And the question then is, if the statutory body disobeys, what happens? Of course, the immediate remedy that may come to the mind of many people is the issue of parliamentary contempt, or contempt of parliament, for example, or some other reference to some other agency, if that could be. But clearly, it appears that Parliament may have acted in a manner that may have resulted in, if you like, an outcome-less situation, which unfortunately may not help everyone. If you speak from a real politics standpoint, one may say that, look, Parliament is a political chamber. The members of Parliament represent constituents. The people who are affected all come from constituencies. Ultimately, somebody must win the public game here. And it seems Parliament has won. Politically speaking, from a political standpoint, Parliament has won. And the General Legal Counsel's back is actually to the wall at this stage, in terms of from the political standpoint. But from a pure legalistic standpoint, clearly, Parliament has chosen a path that is unknown to me, and that is a bit problematic.
I'll thank you for your thoughts. I'll take a short break. When I come back, I'll take Roxanne's response. He and his colleague, the man in the fire, have also initiated a private member's bill on this matter. We'll deal with that when we come back. Stay with us.
Whatever the occasion, with ATL, you can never be out of style. ATL, bringing fabric to life.
Good day energy drink. Excessive drinking can be detrimental to your health. Not recommended for persons.
Welcome back to The Point of View. So let me take Honorable Roxanne Dafia-Mekwa's response. So Mr. Abuchi, Professor Abuchi says that you have some capacity to deal with the matter, but your approach he doesn't understand. Why are you directing the General Legal Counsel?
We are not directing General Legal Counsel. We passed a resolution giving some orders. In fact, 2 orders. The first order was directed at the Minister of Justice. Then there's the consequence. In fact, the first order was directed at the General Legal Counsel. Then the consequential order was directed at the Minister of Justice to ensure that the order was complied with. Now, a lot of people are employing misnomer. That's a wrong use of words to say that Parliament has directed. Parliament speaks only through one medium, and that is called resolutions. When Parliament issues a resolution, there are constitutional provisions where Parliament is supposed to pass a resolution, which are of legal effect. For instance, if we say we are impeaching, if we initiate the motion of censure against a minister, that communication will have to be through a resolution. Can anybody say that resolution passed by Parliament in that regard has no effect? Exactly. So you can't just say that resolutions from Parliament are of no legal effect.
But in the case of the vote of censure, Because it is clear that they know that once Parliament has passed the vote of censure, his position is untenable.
So
then the executive knows how to respond.
So offer the education.
No, I'm saying that, but in the case of what you did with the GLC, somebody will ask, so who should do what if the GLC doesn't act?
We were very clear in who should do what. We gave 2 orders.
Yes.
A direct order and a consequential order.
So if GLC doesn't act, Adame should do
we
something.
We have directed the Minister of Justice. That is why his letter to Parliament
was in response to this.
It's a very pathetic one.
Really?
For the AG to speak to Parliament in this tone.
Why?
Yes. We have oversight over you. He quoted the law himself.
Mm-hmm.
We have oversight over you. You have oversight over the GLC. And for almost a month, you have refused to act. So we have directed you that to act. And then you write to Parliament and say, you have no power to direct me.
Wow.
Yes, that's what he has done. And that, in any case, I've been directed by the President to intervene. Have you intervened? Did you communicate that to Parliament? So what he has done, it is needless for him to create this attrition between himself, his office, and Parliament. It's a very, very unfortunate letter to Parliament in this tone. Look, if you read Article 103, Clause 3, it's a very, very important provision. It says, Bernard, committees of Parliament shall be charged with such functions, including the investigation and inquiry into the activities and administration of ministries and departments as Parliament may determine. And such investigation and inquiries may extend to proposals for legislation. That is even a tail end. People have forgotten. That's why I'm saying that a lot of people have refused to educate themselves on parliamentary jurisprudence. There's something we call committee of the whole. When Parliament sits at plenary and takes a collective decision, that is a committee of the whole. Now, people shouldn't conceive an inquiry as if you must appoint a certain number of people for them to sit in an open and determine and go into a matter for days. No, an inquiry can be conducted in hours.
But to what end? Because in the thing you just read,
yes,
whether it's investigation or inquiry,
yes,
then it says it may extend for legislation. Don't forget you have 3 roles.
Yes,
you have oversight.
Yes,
you have legislation.
Yes. No.
And then you have representation.
Yes, but
so if you do your investigation,
yes,
as part of your oversight,
yes,
your power then becomes legislation. But it cannot. So the consequence of your investigation,
yes,
can it translate into something beyond legislation?
Read the provision. It says that an inquiry into the activities and administration of ministries and departments as Parliament may determine. There's a break.
To what end?
To the end that you give directives. And this is not the first time.
Okay, I get it.
Parliament has given directive to the General Legal Council and they obeyed.
When?
2 years ago. When they admitted only 128 and filled over, it was about 1,800. Yeah. When they admitted only 128, it generated a greater hit than this. But we quelled it. What happened? We invited them because that time we were in session. When they came, they were charging those students who felt that they had passed the paper. So they called for remark. They were charging the 3,000 Ghana cedis per paper to remark. We said, no way. Go and reduce the amount that you were charging the students. They reduced it. Ask the General Legal Council whether they didn't comply with the directive from Parliament. So, Godfrey Adame was then the Deputy Attorney General. He ought to know this. So we are not acting in vacuum. We are not acting in vacuum. So everybody should be calm. All we are seeking to achieve is that by the clear evidence, some persons, we are not asking that all the 2,000 plus students should be admitted. We are saying that by your own records, some 499 students have passed. You are saying a lot of things. They are immaterial. Give them admission. And let's discuss other things. You want money to extend your law school village. We'll give it to you. So if you come to us and you want to justify...
You don't give them the money.
Why? We approve.
Of course.
We,
so
we give them the money.
You have to use the right way.
No, you have misunderstood the process. We give them the money.
But let me take his comment. Just a minute.
No, I'm about finishing.
You are almost done.
We give them the money.
You are done.
No, government will allocate, but we'll give it to you.
By the way,
so we can increase the allocation
by the way,
or reduce it.
What have you and Sosu done in relation to this?
Yes, we have. When we saw this, Sosu is not around, but when I saw this, we have to issue a private member's memo to the effect of introducing a bill that will bring far-reaching changes to...
What's the most important change you're asking for?
The most important change is that we are asking for change in respect of representation of the General Legal Council, and also reform as to the fact that the faculties should be licensed for them to train
their own
students, that we write one national bar exam.
Is Parliament, in your view, going to support this?
Members have received over 100 calls.
So this is going to go through?
It will go through.
So in essence, in this confusion, there's some light at the end of the tunnel.
Yes, but you see, the remedy we seek now is of a timeless nature. The students must go and join their colleagues who started lectures today.
Final comment from you, sir.
Yes, I welcome all the development because we are in a unitary system where the arms of government are constantly pushing and fighting for more powers. And we're in a country where Parliament has been accused of being docile over the years. And so these days we are seeing Parliament waking up and trying to hold leaders to account. But I disagree with the procedure. I like the latest procedure where they are going by private members' bill. In that extent, we are trying to use legislation to correct what we think is an error. But when we issue a resolution, I think it's a wonderful development, but it's not binding. Honorable made mention that in the past they've done that, but he also talked about the procedure. They had invited the General Legal Council. The General Legal Council, if I remember at that time, was also seeking some form of amendment to their...
No. It was after.
No, but they were all together.
No,
and
it
so
was
for
after.
me,
I was at the committee level.
When you invite someone,
we resolved the matter
when you invite someone and you are interrogating the person and you are judged on, it becomes easier that when you say, okay, let's try and do this, they will comply and do. But when you just issue a directive, because he was saying that they can direct the minister, and I beg to differ. They can't direct a minister of state. Parliament cannot direct.
But they can sanction him if.
Of course, yes. That's the beauty of law. That's the beauty of law.
But that's why
they cannot direct a minister.
We can direct
a minister of state.
No,
because the minister of state is under the executive. It's not under you.
The minister
but you
of state,
can summon the minister
of state is accountable to Parliament.
Of course, everyone is accountable to everybody.
So when you come,
but how do you interpret the oversight then?
The oversight simply means that you perform your oversight role by through questions like
so it's more like retroactive.
No, not necessarily, but for instance, if something is going on with say let's take water is not flowing somewhere, you can invite the minister to Parliament and ask questions why it's not flowing and all that. It doesn't mean that you are directing the minister.
To what end?
It does not amount to directing the minister.
Sammy, you are clear misunderstanding.
No, it's not clear. It does not amount to directing the minister.
We need more people in law school, so please admit the 499.
Yes,
so that more people can go to law school. It's not a question
of admit the 499.
So we can all understand the Constitution very well. Sammy, thank you. Sammy Daku is a private legal practitioner. Roxanne Dafiameko is the member of Parliament for South Dai and a member of the Constitutional Legal and Parliamentary Affairs Committee. Professor Kofi Abuchi, thank you, Prof, for joining us, Dean of the Faculty of Law, UPSA. Let the discussion continue. The business dashboard is next with Michael Obodu.
The Point of View is brought to you by Cowbell Coffee. Cowbell Coffee. Taste it, love it. Kel Charcoal Toothpaste. Kel Charcoal. Happy smile. Enterprise Life. Enterprise. Your advantage. Bell Aqua Active. Bell Aqua Active. Stay true to originality.